Hello and welcome to NJS Minds,
the interview series where we attempt to introduce staff members here at Nicholson Jones Sutton Solicitors
to gain a deeper understanding of their perspectives, challenges and triumphs in navigating this company towards its goals.
My name is Nicole and I am one of the legal assistants here at Nicholson Jones Sutton Solicitors for the personal injury and medical negligence teams.
My name is Joel and I'm the contentious probate assistant here at Nicholson Jones Sutton Solicitors.
Let's start with our NJS Minds.
Welcome to NJS Minds. My name is Jack Scott, and today I'm joined by clinical negligence solicitor, Mr. Richard Shillcock. So thank you for joining us today.
No problem. Thank you for having me.
So you've been in the legal profession for over 25 years now. What made you pursue medical negligence rather than road traffic accidents or personal injury claims?
Well, that makes me feel very old, so thank you for that. I actually started out as an RTA lawyer many years ago, but then transitioned to clinical negligence later on in my career. And I have to say, I find it much more rewarding, and it reminds me of why I started out doing this in the first place, which is to help people.
Can you explain the process of filing a medical negligence claim?
Well, each claim is different, but they all share a common theme. What we have to do with all clinical negligence claims is to prove what's called breach of duty, which is very simply where a medical expert does something that no other medical expert would do, or conversely fails to do something which every other medical expert would do. We also need to prove causation, which is, does that breach cause a loss? Now, how we do that is we obtain medical evidence. So step one is obtaining a breach and causation report, which deals with those two things. Step two is, once we have a favourable report, we send a letter of claim to the other side, which is the first notification that the claim is going to be brought. Around the same time, we'll get another medical report, which is called a condition and prognosis report. And this is the report that will set out what the claim is worth. Hopefully, once we have all of that, we can then look to either negotiate a settlement or, if we have to, issue proceedings.
So if I was to make a medical negligence claim today, what would the key pieces of evidence be that I'd need to provide you with as the solicitor?
To be honest, clients don't need to get too worried about the evidence that they need. What they need to do is give us a good history. They need to set out the facts and what they think has happened. What we can then do is obtain the full medical records from the hospital, the GP, the dentist, whoever it may be. And then when they are received, we can go through them, review them fully, and see if the records match up with the initial instructions. If they do, and we think that there's a claim to be had, that's when we can take it further and arrange for medical reports, that kind of thing.
During your time as a solicitor, what's one of the worst cases of medical negligence that you feel you can share with us today?
It's hard to give specifics due to client confidentiality, but the most valuable claims are the ones that have the most catastrophic injuries. Now, sadly, these can often be birth defects or birth complications because the baby's life is irrevocably changed because of the negligence. That said, I'm not a fan of ranking claims based on value. Some of the more lower value claims can often be more challenging from a legal perspective. So it's always good to treat every single claim as an individual claim with its own merits.
So why do you choose to represent claimants rather than defendants?
I've always been a claimant lawyer. I've never been tempted to go to the dark side, as we call it, which is defendant work. And I think the reason for that is mainly because when I set out, I wanted to help people, and I feel that claimant work is the way to do that. I